Man, I'm trying to get Siri to tell me what pre-inventory means. I have to know that. But anyway, happy Father's Day to the fathers that come in or that sees this a replay. Get my lights right over here. Okay. All right, I'm going to put the link in the chat so you can come up. Anybody that wants to come up with us, you're more than welcome. We got to talk about it. Welcome, everybody. Happy Sunday. It's Father's Day. I hope everybody had a good Father's Day that is a father. We're going to take a few minutes, but we're going to jump on in here because it's kind of long. How many pages is that? Okay. Hello, everybody. I came early because I was trying to prepare. So I came in just a little bit early. That's why I'm just giving people time to, catch up or whatever. Because we got about 7, 8. It's long. About 12, 13 pages to read. I'm ready. So we're gonna give them a few minutes, and then we can get started right at 9:30. Okay, that sound good? If you hear, say hi to me, say hi to us, and hit the like, and we'll be getting started right at 9:30 promptly. I'm a little early, so I'm still kind of preparing. So don't never mind me. Hey, everybody. Hey, hey, hey. Happy Sunday. We got about 4 minutes. Thank y'all for being here. Hey, Corporate Luxury. Hey, Alberta. Hey, hey, hey. There's a new motion for a dismissal, a request for a mistrial regarding Juror 6. Like, this is crazy, but we also know that they have to, information that I'm getting is they have to, sorry, information that I'm getting is they have to like file for mistrials, to build up in case in the event that they have to have a an appeal. So we'll see. Yeah, so they have to have a certain amount to, to be prepared for an appeal. And I think that this is just another one. I don't know that there'll be a mistrial. Again, like the judge said, the judge said, where was I? My kids, every time I get live, they start talking to me. But I think that they, you can correct me, Harlem. The judge is supposed to make a final decision on this juror tomorrow, right? So in the event that he just goes ahead and lets this juror go, then they're going to submit this, or they've submitted this in the event of. Is that right? Hey, Alberta. If I didn't say it, hello, everybody. Welcome, welcome. So we're going to get started. All right. Let me pull it up and we're going to get started reading. Again, welcome and hit the like if you haven't already. All right, are we ready? So let me get that off of here. I did that last time. Let me get this banner off. All right. Okay, because it was in my way. All right, I'm going to start now. So this is from, if you guys don't know, Diddy's team. And again, they are requesting a mistrial. So, dear Judge Subramanian, the defense submits this letter in further support of its vigorous opposition to striking juror. Juror number 6 is what we know, a Black man. Mr. Combs would be substantially prejudiced by the dismissal of this juror, and because there is no factual basis to remove him under Fazio, the court lacks discretion to do so. Moreover, if the supposed inconsistencies in his answers to the court's questions were truly of concern, they covered all of that. If the court strikes juror, we respectfully request that a mistrial be declared. We understand that the court has refused to find a discriminatory motive in the government's action with respect to its preemptory, which that word I was looking for, preemptory strikes of this motion. However, we respectfully and regrettably disagree. The government's motion must be evaluated in light of the entire history of the investigation and prosecution and not in isolation. Unfortunately, when considered against the background, it is impossible to believe that this motion is merely a good faith attempt to raise a valid question about the juror's integrity rather than an effort to take advantage of an opportunity to strike yet another Black male from this jury. And I think that we find in here that there has been 7 out of 9 preemptory situations. Preemptory means you have to have a reason or you have to be unbiased about something. And they're saying they're being biased towards these jurors. So A, there is no valid basis to dismiss the juror. To begin with, as the court noted during the morning session on Friday, it does not have discretion to remove a juror where there's a basis, where there's a bias in the removal of the juror, or where there would be prejudice to the defendant, with prejudice meaning that the discharge is without factual support or for a legally irrelevant reason. Generally, so all of those numbers. And then it says here, there would be significant biases and prejudice to the defendant, and there is no factual support for dismissing this jury. So they're saying the prosecution they're holding biases against pretty much Black jurors. First, there is no question Mr. Combs would be severely prejudiced if the juror in question were removed and replaced by the first alternate. We have previously pointed out that this juror is one of the only 2 Black men on the jury, but it should also be noted that he is the jury who is perhaps most similar to Mr. Combs in other important ways. He is a Black man, and then we don't get to see that other stuff. Moreover, this case involves serious charges of sexual misconduct against women who were in relationships with Mr. Combs. As the opening statements and the witness testimony have revealed, the principal dispute between the parties is whether Cassie Ventura and Jane willingly participated in the actual activity at issue during their relationship with Mr. Combs for their own reasons and because they chose to do so, or whether, as the government claims, they were coerced. The fairness of the trial depends in part on having jurors with backgrounds similar to Mr. Combs share their perspectives on the evidence with other jurors from diverse backgrounds during deliberations. Removing this particular juror will deprive Mr. Combs of that important perspective, and it is no answer to simply say that there are other Black jurors and other males on the jury. Second, there is no factual support for the government's position or, respectfully, the court's statement Friday afternoon, which were in stark conflict with the court's apparent recognition Friday morning that the purported, inconsistencies were likely completely benign. As we explained at length in our letter on June 12th on this topic, there were no material inconsistencies with respect to anything juror whoever said during voir dire and in the June 9th colloquies. I think I said that right. And the juror's willingness to perform this public service and his civic duty should be considered a positive rather than a negative factor. There is no evidence whatsoever that he had an agenda or a bias in favor of either party, and no legitimate reason to jump to that conclusion. Indeed, the court had an opportunity to assess the juror's demeanor, not only during voir dire, but also at closer proximity in the robing room during the 2 colloquies. How do you say that? On June 9th. The court never suggested at that time or at any time before Friday afternoon that it had any reason to doubt that the juror was doing his best to be forthright and honest with the court. During government's lengthy quotes from the relevant transcripts, see June 11th letter at 2 through 5, the court being deceitful, and the court indicated it was inclined to agree that there was an insufficient bias to find that the juror was being deceitful and intentionally so, as the government charged. And so the defense submission is really that the answers, given the nature of the inquiry, both in jury selection and during the current process, was vague enough so that the answers could easily be reconciled with each other. And the subject matter of what was being addressed is so far afield from the juror's performance of duties that's not a reason to remove the juror. The real suggestion from the government as to the reason why the juror should be removed is because if you take the inference against this jury's credibility, there is a view that if you can't reconcile the answers and the jury was being deceitful and intentionally so, either in jury selection or in the colloquy, I gotta know how to say that, colloquy in the robing room, then that would be grounds to disqualify the juror. I gotta look the word up, y'all, because I gotta know how I'm saying it right, because I won't understand. Colloquy. So it's COLLOQUY. So that is colloquy, a conversation. They broke off their colloquy at once. Okay, so all it is a conversation, and it's colloquy. Okay, I was saying it right. Okay, so anyway, that's what that means. So just basically it's a conversation. All right, so then we move on. For that to happen, we would need to have further inquiry with the juror because on the current record, there's an insufficient basis to make that determination. And in terms of how we view the inquiry post jury selection, I think that there's a difference. I think that when we address these types of questioning during the jury selection process, there may be an inkling or a suggestion that there's a reason to disqualify a juror for cause. And that has one standard, but it's before the exercise of preemptory challenges and impaneling of the jury. And so that has one standard. I think the defense's suggestion, and I think it's consistent with a lot of cases, is that that default actually flips once you have the jury actually in the box and you have a regular jury and alternate. At that point, you need something more to disqualify a juror. And that case cases cited by both sides have situations presented that are far more extreme than what's been presented here. Moreover, although the court indicated a preference for further inquiry, it specifically noted, I think that it is likely that what we will hear will be a perfectly innocent explanation for the answer. I don't think that they're irreconcilable. I think that for the reasons that the defense has stated, there's a way to reconcile the entire record. The court also noted that the only reason why this situation even came up is because a statement that was made on the juror's own volition to jury department staff in a friendly and in an offhand banter. The court further observed, and there's perhaps an understandable way to reconcile all of these issues, which is that I believe that the question that was initially asked during voir dire during the group proceeding was, where do you live? And then kind of, who do you live with? But based on the answers that were being given by the group, it could have been that the juror thought, where do I live? I live in the Bronx. And that would be consistent with everything that we've heard. Because he indicated that he had moved out of the Bronx in the last 2 weeks, and there might be some ambiguity about how much time he was spending in each place. But that's at least what he said. As to the second question, he might have understood it to be who in your family group. As to that question, he indicated his fiance and his baby daughter. And so you can reconcile these things, and given what we're talking about, which is where do you live, and kind of basic questions, which is where do you live and kind of basic questions, it would be surprising that someone would try to make up something about it. Maybe even if there was some inconsistency, it wouldn't rise to the level of removal of a juror. The defense, given the various constitutional and other rights that the defendant enjoys. The defense expressed concerns about any further inquiry because of the likely negative and intimidating impact it could have on the juror, especially after the government started suggesting a line of inquiry that could lead to a concern that the juror's employment was somehow in jeopardy. In response to the court's comments, the government ultimately stated that the most prudent thing to do to ensure the integrity of the proceedings would be to have additional inquiry. It endorsed further fact-finding, stating that such fact-finding was necessary to ensure the integrity of the proceedings. The court said it would consider the parties' arguments and whether to conduct further inquiry later. So in light of the decision in the morning, the defense was stunned when the court announced at the end of the day, in stark contrast to its extensive earlier remarks about why there was an understandable way to reconcile the juror's answer, that it believed the juror was either unable to follow simple instruction and answer simple questions, or was shading the truth or being deceptive, and would dismiss the juror without further inquiry. Respectfully, there is simply no evidence to support the court's very serious accusation or its stated concern about the juror's ability to fairly and impartially apply the rules of the law of the court to the facts of the case, to consider the evidence in a fair way, and to follow the instruction of the court. The court later stated that when the juror said he had a New York license and still maintained his residence in the Bronx, this was somehow nefarious and suggested an effort to try to get onto the jury. But the juror was already on the jury and has sat through over 4 weeks of the trial, have been willing to serve, which many citizens aren't, and having dutifully devoted all this time to attending the trial. Why would the juror not want to complete his service? Why would he not emphasize that he is still a legal resident of New York, even if he spends several nights a week? And they blacked that out. There is not a shred of evidence that he had a pre-existing agenda when responding to voir dire questions, as opposed to a willingness to do his civic duty, and the statements the court cited were made after weeks of service, not at the outset. This was, okay, I don't think I need to read that. Let me see. This was consistent with the court's initial impression of the juror's response during the June 9th colloquies, when the court had the benefit of observing the juror's demeanor. June 9th scaled. Additionally, the court cited United States versus Arlene 600F, whatever that is, as support, but that case involved a juror's inconsistent answers about misconduct, which they're saying that don't match this. The juror had listened and watched a proceeding not meant for the jury. There is no reason to believe juror, we're saying number 6, has failed to follow the court's instructions not to discuss the case with orders or view media reports about the case or engaged in any other prohibited conduct during this trial. Should the court exclude juror on the current record, it will no doubt have a chilling effect on minority jurors' willingness to okay, let me start over. It will no doubt have a chilling effect on minority jurors' willingness to serve in the future, a step in the wrong direction. The government has previously argued that racial disparities in jury service exists because Black and Hispanic people disproportionately fail to respond to jury qualifications questionnaire. United States versus Slaughter. But this juror answered the call and is definitely performing what the court stated was a tremendously important task recognized by the Constitution itself. We should invite his service as well as the service of other potential jurors in his community, not discourage it. Third, if the bar is this low, then all that's blacked out to avoid any biases, Fazio 770, then it goes to a whole nother page. June 13th, sealed. All that is sealed. That's sealed. June 13th, sealed. Okay. The government's motion continues a pattern of overreach, suggesting a discriminatory motive in challenging jurors. Although the court denied our Batson challenge, and said it found no biases to suggest the government had a discriminatory motive when it sought to strike this juror, we believe that motive is supported not only by its remarkable decisions to use 7 of its 9 preemptory strikes on Black jurors, but also by the history of the investigation and prosecution, which has been characterized by extreme government overreach from the beginning. Preemptory challenges during jury selection. The court accepted the government's proffered reasons for its preemptory strikes of Black jurors as race neutral. Voir dire TR 781. Nonetheless, it is important to note that for many of these jurors, the purported reasons themselves were based on the jurors or their relatives' interaction with law enforcement, including prior convictions. But it is well documented that there is a long history of systematic discrimination that has led to mass incarceration of Black and Hispanic people in this country, and of discrimination in Brow law in Bow law enforcement treats them in comparison with white people. Gosh, I struggle right there. I don't know why. With white people. Then we move on, describing heightened police enforcement of Black and Hispanic people in the district. Moreover, a 2022 study of 3,200 innocent defendants exonerated in the U.S. since 1989 revealed that Black Americans are 7 times more likely than white Americans to be falsely convicted of serious crimes. Citing a prospective juror's former conviction, or their relative's former conviction, or the fact that they have had negative interactions with the police only reinforces the race discrimination that led to the over investigation and over prosecution of Blacks and other minorities in this country. People should not be precluded from serving on juries because of a prior conviction or a relative's prior conviction, or the fact that they have had a bad experience with some police supported their car had a bad experience when the police stopped their car on a pretext or conducted a stop and frisk on a pretext. Indeed, if they had a negative experience with the justice system, that is a perspective that is important and useful for all diverse juries. For these reasons, in recent courts, like the Washington state courts, have implemented rules foreclosing the use of a preemptory because a jury has had prior contact with law enforcement officers or has a close relationship with people who have been stopped, arrested, or convicted of a crime. Washington State Court Rules, General Rule 37B or H. Here, the government justifies several of its strikes on this sort of basis. For instance, it said one reason for the first strike was that the juror had a fiance that served 4 years in prison for a drug conviction, Voir Dire TR 775. A reason supplied for the second strike was that he had been arrested 3 times, including for harassing a police officer. The fourth strike was a juror whose ex-husband had spent 21 years in prison for attempted unaliving and remained close to him, and had a brother who had been incarcerated for 2 years based on a rug conviction. The government justified its fifth strike in part on the basis that the juror had 2 brothers who each did time in prison for felony convictions. Another strike cited inconsistent explanations of interactions with the police. History of investigation and prosecution. For starters, it is notable that Mr. Combs, one of the most successful and self-made Black men in America, and a person who was an icon not just in the Black community, but in the music industry, the fashion industry, and otherwise, was indicted by the SDNY's Civil Rights Unit. When that unit was established, former U.S. Attorney Damian Williams was quoted as saying, "White supremacist groups are on the march. Anti-Semitism is on the march. Anti-Asian violence is on the march. Abuse of the most vulnerable in our society is on the march." But this prosecution has nothing to do with civil rights enforcement. What is being prosecuted is allegations about private sexual activity Mr. Combs engaged in with 2 of his former girlfriends and third parties. Study shows race is a substantial factor in wrongful convictions, equal justice in initiatives. Okay, we can move on. All of this was part of a coordinated effort to try to destroy one of the most successful Black men in American history. All of Mr. Combs' ventures and entirely legitimate. Wait a minute. All of Mr. Combs's ventures are entirely legitimate, and the government has never suggested otherwise. Instead, the government's case is all about his personal life and what he and his romantic partners have done in the privacy of the bedroom. As the trial has shown, the most significant evidence against Mr. Combs involves DV incidents normally dealt with by local authorities or family courts. Yet the prosecutors have made a federal civil rights case out of how Mr. Combs and his former girlfriends conduct their private ex lives. The theory of prosecution not only has nothing to do with civil rights enforcement, but it is also unprecedented. Indeed, we are unaware of any other federal criminal case charging racketeering on ex trafficking based on allegations that a man and his past long-term adult girlfriends sometimes brought a third party, a male escort or entertainer, into their actual relationship. Since its inception, the case has been rife and overreach. It has been rife with overreach and unusually aggressive tactics normally reserved for prosecutions of violent gangs, organized crimes, and terrorism. The purported victims never complained to law enforcement. Ms. Ventura's lawsuit was settled for $20 million, and she never made any complaints to the Southern District of New York or any other law enforcement agency. Nor did Jane. Indeed, the government labeled her a victim in whatever that says, and bail arguments long before it had even interviewed her. And she claims to have testified only because she was compelled to testify by subpoena. The government, that tells me right there, we already knew that. The only reason she testified is because she was subpoenaed. She's still in love with Sean, and they're saying this is ridiculous. The government has devoted enormous resources to this care. The undersigned are not aware of any other recent case involving more than 5 AUSAs. What is that? AUSAs, whatever. And here we have 6 at trial, along with 2 filter team ASUAs and multiple actively involved supervisors. Additionally, the Department of Homeland Security assigned multiple agents to the case, and numerous other agents have assisted at various points, including hundreds of heavily armed agents in combat gear who executed military-style raids, complete with armored vehicles on Mr. Combs' Los Angeles and Miami homes in March of 2024. And the government also apparently retained a highly paid jury consultant in this case, which is exceedingly rare for the government to do so. A consultant who may well be advising the prosecutor in connection with the instant motion. The Southern District of New York refused to engage with defense counsel during the investigation. Mr. Combs' lawyer approached prosecutors as soon as they learned of the investigation, even before the warrants were executed, and requested an opportunity to meet. Yet the Southern District of New York refused then and repeatedly refused thereafter to engage with counsel substantively throughout the investigation and leading up to Mr. Combs' arrest in September of 2024. The prosecutor also refused to allow Mr. Combs to voluntarily surrender, presumably to create another media spectacle like the one orchestrated during the raids discussed below. The SDNY used misrepresentations and material omissions in warrant applications. Although the court denied our Frank's motion, the defense has documented how the SDNY obtained the March 2024 warrants to search Mr. Combs' home's person and all the electronic devices used in materially misleading application. The omitted extensive evidence undercutting the credibility of They omitted extensive evidence undercutting the credibility of Ms. Ventura and other witnesses, the warrant application on the established probable cause. For instance, when obtaining the warrants, the government completely disregarded extensive evidence then in its possession showing Mr. Combs and Ms. Ventura's relationship was, though at times toxic, consensual, and loving. So they're saying, yeah, it was toxic, but they was both saying yeah to what they wanted to do, and they loved each other. The applications also relied on several other witnesses the prosecutors later admitted were not credible. These witnesses were part of a feeding frenzy of grifters who were trying to extract money from Combs after the Ventura lawsuit became public. Yet the prosecutors failed to disclose the financial motives of these witnesses and concealed exculpatory evidence that the government had in its possession when it sought the warrants. Investigators used excessive force and created a media circus during the raids of Combs' homes. The search warrants were executed in a manner calculated to garner press attention, sensationalize the case, falsely portray Mr. Combs as a dangerous and taint any future jury pool. Agents leaked the government's plan to the press in advance to maximize media coverage and put on a show. The agents used excessive force against Mr. Combs' children who were in his homes, doing nothing wrong. Wow. One agent held a semi-automatic rifle to the head of Christian Combs, even though he was visibly complying with the agent's demand. Another had a semi-automatic rifle with a laser sight trained and the orange dot visible on the middle of the chest of, oh my gosh, on the middle of the chest of Justin Combs, who was also complying with the agent's instructions. The agents then handcuffed them and paraded them in front of the news cameras and a TV helicopter invited by DHS, who were waiting to get salacious footage of this staged prep walk of two innocent young men. Wow, that's deep. That's deep. Investigators leaked a steady drum beat of the false and prejudicial information to the press until the court issued a broad gag order opposed by the government. Throughout most of 2024, DHS agents repeatedly leaked information about the investigation to the media, including extensive amount of highly prejudicial and false information about minors, dungeons, cameras in bedrooms, and a host of other prejudicial information. Why am I struggling with that word? Information that has caused online conspiracy theories to multiply. As the court is aware, the prosecutors repeatedly denied that these leaks emanated from its case team by describing the team in an anti-officially limited way, and even opposed a request for a gag order that would prohibit all DHS agents, not just limited to the SDNY claimed were not just the limited few SDNY claims were on the case team from leaking sensitive information about the case. While this litigation was ongoing, the leaks continued unabated. It was only after the court issued the broader gag order the defense saw that the leaks finally ceased, long after the jury pool had been deeply tainted. Since then, the government has repeatedly invoked the gag order and Local Rule 23. I too prevent the defense, which has a right to try to combat the unfair tsunami of nonstop negative coverage from any media engagement. At the same time, the government has failed to oppose in any way the numerous apparent violations of the rule by alleged victims and their counsel. We're almost done, y'all. Prosecutors insisted on detaining Combs even though he did not present a risk of flight or danger. The prosecutors insisted on detaining Mr. Combs even though he offered to surrender, traveled to New York once he learned he would be charged, and obviously was not a flight risk. They also misled the courts that held the initial detention hearings. For instance, they told the district court the CNN video refuted Mr. Combs' account of the Intercontinental event, that the incident occurred after the couple had an argument over Mr. Combs' relationship, and that was involved in a that involved a phone. They said that was just not what happened and just another cover up, just more lies. Even though nothing in this trial evidence contradicts the claim that the fight occurred because of jealousy in the relationship, they cited a third victim, Gina, and then it's blacked out, who the prosecutors have entirely dropped from the case. Prosecutors surveilled Combs in jail and invaded the defense camp. The prosecutors next took advantage of Mr. Combs' incarceration to spy on him and invade the defense camp, violating his attorney-client privilege and his First Amendment right. As the court is aware, shortly after Mr. Combs was detained, a BOP investigator began monitoring his communications, including calls with his attorneys and sharing information with prosecutors. During an allegedly unrelated October 24, 2024 general sweep of MDC Brooklyn from the contraband and evidence of corruption, agents completed their search of certain parts of the facility and asked SDNY whether or not they should continue the efforts and search Mr. Combs' unit. An SDNY supervisor told them to search Mr. Combs' unit because of the government's interest in Mr. Combs specifically, and law enforcement agents proceeded to do so. During the ensuing search, the investigators who had been working with the prosecutors confirmed there was no contraband among Mr. Combs' personal effects, but nonetheless rifled through his possessions and photographed Mr. Combs' notes reflecting conversations with his attorney and idea for defense strategy. The investigator then told a member of the case team about the notes and turned them over to SDNY, which tried to use them to oppose a renewed bail application, claiming they showed Mr. Combs was trying to obstruct justice. The court granted a defense application to order the prosecutors on the case team to destroy their copies of the privileged note. Prosecutors violated Combs' free speech rights. The prosecutors continued their spying and next argued that Mr. Combs' other writings and communications from MDC supposedly involved obstruction, even though these materials were clearly protected by the First and Sixth Amendment. Some reflected his participation in defense efforts to obtain material that could be used to challenge the credibility of the government's witnesses. Other writings describe Mr. Combs' view that the prosecution is racist and his desire to get the message out to counter all the negative media about the case. The SDNY even went so far to claim Mr. Combs' request that his children post a happy birthday message to him on Instagram was an effort to obstruct justice, because Mr. Combs hoped it would present him in a more positive light to the public and undo some of the taint to the juror pool caused by all the negative publicity ginned up by the government and civil plaintiffs' attorneys. Prosecutors abused a filter team to access privileged material. The government's invasion of the attorney-client privilege and the defendant camp has not been limited to its seizure of Mr. Combs' notes. Throughout the case, SDNY has misused a purposed filter team, which was supposed to ensure that the prosecutors handling the case were not exposed to privileged material on the numerous electronic devices and internet accounts the government has seized and searched. Following execution of the March 2024 warrants, defense counsel provided the prosecutors with the names of attorneys who had represented Mr. Combs at his businesses so that potentially privileged materials could be segregated from the case prosecutors. Our understanding was that a filter team would not provide any potentially privileged material to the case prosecutors without first affording defense counsel the opportunity to review the material so that counsel could assert privilege if necessary, and so that any privilege disputes could be resolved by the court in camera. Instead, the filter team has repeatedly passed along potentially privileged information without first seeking our input, requiring us to claw back privileged communications after the case team had already been tainted by exposure to these materials. Prosecutors used the grand jury to help unscrupulous plaintiffs obtain publicity for wildly false claims. So after Mr. Combs' arrest, while continuing its investigation, the government publicly paraded witnesses into the grand jury to feed nonsensical media narratives that they knew were false. This created an atmosphere of legitimacy surrounding the many false and wild claims about Mr. Combs and the media circus created by unscrupulous plaintiffs, lawyers, who have encouraged people to file bogus lawsuits against Mr. Combs. Prosecutors attempted to introduce unreliable, decades-old, highly inflammatory allegations and used allegations about additional victims who never testified to obtain search warrant and seek detention. The government attempted to prop up its case with old, unreliable, and highly prejudicial, and inflammatory Rule 404B evidence, much of which the court correctly and fortunately excluded in granting the defense's motion in limine. And although the court denied the motion to exclude the testimony of one alleged victim, another girlfriend who had no interaction with any of Mr. Combs' employees or the alleged RICO enterprise, that individual apparently has decided not to testify. Likewise, the government spent over a year claiming that Mr. Combs' former girlfriend, Gina, was a victim and used the allegations to support arguments for bail and to obtain warrants and presumably in the grand jury, even though that's blacked out. And the government did not call her as a witness. Despite including her in the indictment, the government has not elicited any evidence at trial that could possibly support the conclusion that she is a victim. Prosecutors have engaged in other misconduct during trial. Wow, this is deep. We recognize that the court has denied our 2 mistrial motions, but as the court is aware, we believe the government asked inflammatory and highly prejudicial questions of Inspector Jimenez to try to suggest Mr. Combs had somehow orchestrated the destruction of fingerprint evidence in 2012 and then presented testimony from Cassie Ventura and Brianna Bongolan that it knew or should have known was materially false. The government's history of these extremely aggressive tactics in this case is critical context against which its attempt to remove Juror must be evaluated. In this case, the prosecutors have repeatedly flouted their offices, self-proclaimed tradition of doing the right thing the right way for the right reasons. Their pretextual motion to dismiss Juror is just one more attempt to gain an unfair advantage at the expense of Mr. Combs' right to a fair trial, which is all we ask this court to preserve, the right to a fair trial. And we are concluding, for the foregoing reasons, the court should allow Juror to remain on the jury. If the court truly believes his statements raise serious concerns about his ability to follow instructions, which we respectfully admit would be an unfair and unsupported conclusion based on what were at worst imprecise answers to the court's questions, then in fairness, then all that's blacked out. If the court dismissed this juror, the unfair prejudice form replacing him with the first alternate at this late stage of the proceeding warrants a mistrial. Respectfully, Diddy's whole team. There you have it. So, all right, we're back. Let me go back over here. All right, you guys, thank y'all for engaging. Hey, Montana. Hey, everybody in the chat. Hey, hey, hey. So here you have it. I know Faith is 30. I should have known I am. Especially after all of that reading. I am Montana, and I got my water. Hello, everybody. Thank y'all for being here. Let's talk about this request for mistrial. I'm going to remove that. If you guys want to come up, the link is there. There's a couple of things for me. Like, again, this is really a brilliant request for mistrial. And, but again, I'm just not going to even make any, I'm not going to even give my opinion of if I think that this should be a mistrial or not. Do you remember the breakdown of the male jurors? No. If you're asking me, I don't. Let me look at up here. All right, so I have questions for y'all, especially you, Montana, because I know how you. Well, how did I do then? How did I do? Anyway, I do have a question. So, just hearing that, it kind of just raises some red flags for me when we talk about the prosecution. If in fact it is true that he really didn't get like they were tampering with attorney-client privileges, it's just not right for them to do that if that has happened. They wrote this again in a very brilliant way. And it's so long because they took the time to go in and to highlight every point that they are trying to make and then give reasons why, or give evidence, a clear reason why that this should be a mistrial if they dismiss juror number 6. They are saying that the only reason really that they have that they really don't have a substantial reason to dismiss this juror, other than this is another black man that you're dismissing on what are you standing on? Basically, because of he's been on this stand for the entire time. He lived in the Bronx when this started, and 2 weeks ago, like, he moved to New Jersey, or he's going to New Jersey to see his family. Like, hey, beauty, is me. Hey, everybody, if I haven't called you out, I apologize. I don't remember the nationalities either. I don't remember, but it was said. I mean, we were told that, but I just don't remember. But anyway, so I don't know that, that of course they're going to give him a mistrial. But they said some very interesting things in this request. I don't agree also with, do we think, or do y'all agree also that, like, when they talked about the exactly, and they're saying that happened, Montana. So I just, at this point in the game, I just don't know. I don't know if they in fact violated him with his attorney privileges, if they in fact went and raided him in his jail cell because the government was wanting him anyway, like there is just a lot that I'm just not clear on. I just don't understand. If all this is going on, then they have to give him a mistrial. Even just beside the juror, even beside letting this juror go, because they're saying this is you, they're pulling the race card now, right? His girlfriend, did 4 years. Maybe his brother had a run-in with the law, so they're looking down on them. And that it is true about the ratio with black and white convicted felons or convicted people, that a lot of times there are a lot more black people that are convicted wrongly other than whites. And they mention that. So they have a lot of valid points here, but I'm just not able to say, what I think the judge will do at this point, because so far this is the third request, and it hasn't happened. I was listening to somebody today, not about this because we just got it, but just saying that at this point, Diddy's going to get off. They think that Diddy will get off. He's going to be found not guilty, and not even do any time. Now, do I believe that? I just believe that he is going to get some time, and that he's going to get time served with the time he's sitting there now that may release him immediately. I don't know. It just depends. But I just don't know. I just don't know. Are y'all going to come up tonight? Let me get this off of here. And also they were talking about like seeing a pattern of, this preemptory, this bias that the prosecution is showing, a bias against Diddy and against this juror and against black people. And they're finding a way to, like, they didn't allow him to turn himself in for whatever their reasons were, and that they didn't give him bail because of a flight risk, which I agree with them there. Like, he wouldn't have flown to New York to turn himself in if he was a flight risk. He wouldn't have offered up his mom's passport and all those millions of dollars if he was going to flee. Do I feel like he should have got bond? They should have gave him a bond. If you tampering with witnesses, you're not going to get a bond. But what they're saying is he was never tampering with witnesses, but we know about all the phone calls. So you can't tamper with witnesses and try to pay them out and persuade them to not testify so you can beat a case like allegedly you have always been doing. And so does he deserve, to make bond? I don't know that answer. Part of me says, why not? He's going to be on house arrest. He's saying, I'll be on house arrest. You guys can have your own security guards around, like whatever, And then a part of me is like, if you are really bothering people and calling people 67, 90, 11 times a day, then no, you don't deserve that. So I'm just in the dead middle of everything. I'm not for the prosecutor. I'm not for Diddy. I'm just in the dead middle and just trying to figure it all out. I do think it was horribly wrong for the way that they handle his kids. No matter what, they shouldn't have been handled like that, especially if they were cooperating. So I think that was just horrible in itself. So Harlem, thanks for coming up. Like, what do you think? What are you saying now that we've read that entire thing? And I've heard some points in that I'm like are very viable points. Like, yeah, why not? And then I'm hearing some things. I'm like, but you even know that he had been tampering with witness, talking about his lawyers, right? Just don't know.
Yeah, see, that's why he didn't get a bail, because they say he was witness tampering because it was Kalina and it was another guy.
Can you start over? You just popped in. I couldn't hear you. I'm sorry.
Oh, I'm sorry. You can hear me now?
I can hear you.
Oh, yeah, I was saying, they didn't give him the bail because he was witness tampering. It was Kalina and then it was a guy. I
Yeah.
have to find the document because it was an employee number one or number two that he had been in communication with that was supposed to be a witness. And they didn't call all of their witnesses, because they decided that they're going to rest this week, but they had more witnesses.
Right. And I believe that. And I'm like, how in the world can they say they're not going to use all their time when they had a ton of witnesses? Like, why do you think they're not going to call these witnesses now? Do you think it's because it's been tainted, or why do you think they're not going to call them?
I think they believe that they've proven the case. And I think that's why the defense keeps wanting a mistrial to me. Because a
Because
mistrial, it's not going to release him.
right.
Like we were saying, it just starts the procedure over again. They have to find a new jury. It's to me, they now know how to defend the case because
Mhm.
they know what the prosecution is coming at them with.
Right. Um So you feel like what I'm hearing you say, I think, is that the reason the defense keep fighting for mistrial, this is their third request, right? Is because they even feel like the prosecution's point has been proved. It maybe it's very vague, maybe it didn't take a lot to prove it, but it has been proved, and they think that he will be found guilty if they don't get a mistrial.
That's what I'm believing because they have proven some of the charges,
Uh-huh. Yeah, I believe that.
and I just don't know like that the juror, like he just got comfortable with the staff, and I think he shouldn't have got comfortable with the staff because you don't know these people per se.
I
Like
believe,
even the other jurors, you didn't have to share like information. I understand how people, try to be friendly and, talk to people and what have you, but it's some things that you just don't share.
yeah. And I think, with his caliber, the celebrity status that he has, that you're right. Like, you can't just be getting all involved with everybody. That's why you hire a team, and you don't make yourself accessible to people. I know, you don't want to treat people wrong or whatever, but you don't know what people's motives are, and they could very well set you up, for money, all about money and whatever else. And so I agree with you there. He made himself just too accessible, I think. Um, but again, they can't, if he was truly, and there's evidence to prove it, if he was truly tampering with witnesses, then you can't argue the bail part, right? But when we talk about juror number 6, and he's a black man, and all these reasons they gave in this request, do you think that it do you think, now that we've heard it all, that this um is grounds for mistrial?
No,
Still no. Okay.
because that one juror they know was for Puff. Like everybody in the courtroom saw
Yeah, they
that
know.
juror, and
Yeah.
it's three of them, so it's two more
Yep.
that
And
they
I'm
were for
sorry.
Puff.
And you heard them saying, the people in the courtroom was saying it, like, he's around that age, that he was like in that era, and that they know that he could probably, like, cause it to be a hung jury. But do we really think that's the reason the prosecution is saying he got to go? Or is it really because he's been telling different stories about where he lived, how he lives, New Jersey, New York? Like, is that really grounds for it? I don't know, Harlem.
Because if he actually doesn't live in the state of New York,
He
That's where
can't.
the juror pool was being pulled from. If he lives in the state of New Jersey, then yeah.
But and does that mean? Well, I guess so because they gave us a list of the surrounding. I got a list of the surrounding. It was like the Bronx. It was it was like 4 or 5 that you had to live in those particular counties or whatever. And but my question was, when he got chosen for the jury to be on the jury selection, he was living in the Bronx. He's saying that, and then he says he still lives in the Bronx, but he goes and see his girlfriend in New Jersey a couple of times a week. Like, and he still has a New York license. He's still working in New York. Like, there, how do you prove he's living in New Jersey? Is it because of his inconsistency? Because they asked him 3 different times, and they say they got 3 different stories. He says, let me put this up here. Montana says now he see how the average black man easily gets convicted for something they really didn't do. So if he's free again, he needs to help sponsor some of them in innocent programs to help convicted people. I agree with that. But so Montana, you think he's just being done wrong, period? Because what what it just said, that he's being looked like a monster because of what goes on in the privacy of his bedroom. Like, yeah, there was some DV, okay, but then there was some consensual things happening, and they were all of age. They were all adults. There was no minor, nothing. And so why should he be convicted on those grounds? But it's more than that to me. It's deeper than that. And they're trying to go, they're trying to discount the other things, I think.
Yeah, it's more to the case than what it is. I always said that Puff was just a puppet and the puppet masters controlled him.
Above him.
Kanye was the wrong person to come to court to support him. Where are those millionaires, white guys that he's been in business with? That's his kid's godfather and what have you, and whatever. Where are they at to support him?
Now that's a fact, Harlem. I didn't even think that way. But you want to know why I think now that you said that they not coming? What did they have to do with everything? Don't you think that he was groomed when he came in this business?
Yeah,
He didn't just that up. He was groomed, allegedly, my opinion, when he came into the business. And then once he felt himself, and he was all in, now he's grooming and doing other people, allegedly. And so it would be really bright. It would be a really bright thing to have those people like come and support him, but they're not coming because of the fact, what do they have to do with stuff? What are they telling Puff to do?
But they not coming. They not coming. It's just to come. Like Kanye came, which I say he's the wrong person to come. He came for 15, 20 minutes. They could come and just sit and watch and leave.
And go.
You were there to offer your support, but you're not doing that because you know that you're going to get pulled up into the madness.
That's it. That's why they're not coming. Don't even want to be on the radar right now.
Yeah, like how do you make these people the godfather of your kids?
And you ain't show up.
And think that they're going to be there for your kids. A godfather, a godmother is somebody that in the absence of the parent is there for the child.
Absolutely. Like a parent stands up like a parent for that child.
Yeah.
And who has, according to Diddy, no one has showed up for him and his kids except for Kanye. Not one person has showed up for him and his kids.
Right.
So I appreciate getting that. I really do, because I wasn't aware. I was like just sitting all day. I was like, I need to make some videos, but that came. I was like, bloop, go put your eyelashes on. Yeah. So, do we have? Is it just Montana? Are you a father or no? He hates her getting treated like a regular. Okay. Now he mad that he sees his money not holding no weight. Yeah. So they don't care. They all that money he offered to 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 get a bond. All that he offered, they still said no. Happy Father's Day. They still said no. We're not giving you no bond. So right, your money don't hold weight right now. They don't care about your money. This is the feds we talking about. They don't care at all. So tomorrow's going to be interesting. It's going to be really interesting to see everything, and especially if we have this now that they're going to deal with, and then Brandon Paul allegedly comes on, and testifies. I really am just distraught at the point that Gina didn't show up, that Gina backed out. And they said that this lady that just came out, Chelsea, then said that she wanted to say her name, that if anything, they should be trying to get her there before they rest this week. But I don't even know that will happen. But
Yeah,
would be
because they would have to prepare her and, you know.
yeah, it just ain't gonna happen. It just don't seem like it's gonna happen. So right now they're saying they have at least tomorrow or till Wednesday, right? So that's telling me, okay, if they bring Brandon Paul, who else is left before they close? Like, what is the plan? What is the process? That's what my question is. I don't know. I don't know what they're gonna. I guess the prosecution feel like they've done a grand job, and they feel like they've nipped it in the bud, and they did what they came to do. But I still don't know.
Yeah, I don't know. I don't
We
know who
read
else is
part of
coming other than Brendan. Brandon.
yeah, yeah, I don't know either. But it'd be interesting to see what they got left.
I think it was a summary person.
At
That's a
the end,
government person, I think, that goes over everything.
yeah, that'll be after the last testimony, right? Then they'll come and they'll summarize everything. Um, I don't know. It's a
Yeah, I
lot.
don't.
And it's a lot to take in. It's a lot for them, on both sides, But somebody got to get it right. Somebody has to get it right. Even your glasses needed a I'm gonna need you to go night night. Yeah. So that was a long one. That was a long one though. My words was running together. My eyes was doing this.
Yeah,
Like
it's a lot.
it was a lot, but it was really interesting though. How they worded it, how somebody took their time. See that right there, how they prepared that quick, tells you that there's somebody sitting there on the team that does this, that's sitting there writing the stuff up in real time so that we can present for mistrial, so we can be ready for an appeal if we have to in real time. So
Yeah,
because
Shapiro is the appellate lawyer, so she's the one that will do the appeal.
yeah,
Hmm.
so they did good. I mean, it was really written out really well. But again, I don't think it's grounds. I said I wasn't going to say my opinion, but I don't think it will be grounds for mistrial. I don't think the judge is going to do it. And now they're saying that the judge is all pro the prosecution. But for me, and this, y'all can tell what y'all think. But for me, I think the judge has been fair. Like, where has he not been fair at in this trial?
Yeah, I think he's been fair.
Yeah,
I
I
don't
think
think he sided with either side.
I don't either. And I don't think that he's mismanaged his courtroom. I don't think he's mismanaged, how they do. Like, there's going to be some things whenever they say, when he sustains things and don't let people go on, or he's not allowing things in for evidence, or he does allow things. I mean, he's just doing his job, and I think it could be worse. Oh, it could be worse. And so I think he's done a fair job so far.
Yeah.
Yeah. So I appreciate it, Harlem, so much. Anyway, you guys, so that's that on that. Since Montana said the whole week has been done, y'all don't even have to show up tomorrow because I took care of it. But anyway, tomorrow morning we'll be hollering at you guys really quick. We're definitely going to be following it because I want to hear everything Brandon has to say. I want to hear all the questions as much as I can, and then we'll follow up on that tomorrow night. I do have Lady Hiawatha who is going to join us Thursday. She's really close to some celebrities and in the industry kind of, and so she knows, keeps her ears to the ground, and then she reports on just politics and everything else. So I wanted to bring her on Thursday and see what her opinions are. And I think from there we can get some more connections as well. I did hear back from one of our people that are in the courtroom that we asked on, and he said that as his schedule is booked, but as soon as trial is over, he'll come, which is fine because then we can really talk about stuff.
Right.
So that'll be one that we have lined up. He said he definitely will come. So I've written it down so we don't forget. So it's gonna be okay. We're gonna do good. I'm really seeking out an attorney. I want to get an attorney on here, so we'll get that done. But anyway, you guys, I appreciate y'all being here this late. You say it's not late over there, but I appreciate y'all coming on a Sunday night, listening to me read the request for mistrial. We will be back here tomorrow evening, but definitely I will be going live a couple of times tomorrow, just with updates. If you guys have any information, any documents, any new things that you guys want to talk about, send them our way. We're open to it all. And with that said, I'm going to go for tonight. Again, if you're here, thank you for being here. Thank you for hitting the like button. If you haven't subscribed, go ahead and subscribe and also become a member. We got 5 members. Yay. So we're getting there. We're getting there, and I appreciate y'all. So we're going to go, y'all, and I'll talk to y'all tomorrow. Y'all have a good
All
night.
right. Good night.
Good night, everybody.